Hello, and welcome to another session of the Publish with Purpose Virtual Summit brought to you by Emerald Lake Books, where we're serious about your publishing success. I'm your host, Tara Alemany, and the founder of Emerald Lake Books. Today, we're talking with Jonathan Kirsch about legal tips for authors. Hi, Jonathan. Thanks for being here.
I'm happy to be here. Thank you.
I'm so looking forward to this conversation. I've listened to you speak a couple of times with IBPA, and you're just always so knowledgeable, and you make something that's intimidating a little more approachable. So I'm really looking forward to this.
Me too.
All right. So for those that don't know Jonathan, I'm going to share your bio a little bit. Jonathan Kirsch is a publishing, privacy, and intellectual property attorney based in Los Angeles, an expert witness on publishing industry matters, and a lecturer and consultant on publishing matters. Kirsch is rated AV preeminent by Martindale-Hubbell, and his clients include book, magazine, newspaper, audio, video, and electronic publishers, authors, agents, distributors, designers, artists, and photographers, among other publishing industry, business, and professionals. He has long served as general counsel for the IBPA, which is the Independent Book Publishers Association, and lectures annually at IBPA's Publishing University. Kirsch is the author of 13 books, including 2 books on publishing law, and a longtime book reviewer who currently contributes to the Washington Post. That's impressive.
I'm very proud of that.
Yeah, that's interesting. So how did you get started working with authors?
Well, I became a lawyer while I was working at the Los Angeles Times as a writer and an editor. And I had been given advice by the guy who interviewed me that I ought to go back to graduate school and get an advanced degree to acquire a specialty as a reporter. And he said, it doesn't matter what specialty, but politics, law, government, whatever. And I was thinking about that, and I decided I would go to law school because then I'd have a second profession. Mm-hmm. So for the first 7 years of my 7 or 8 years of my post-college working life, I was a journalist. When I had kids, I decided, my wife and I had kids, I decided probably time to move on to law. But because of my background in publishing, I cultivated a publishing law practice. As you've mentioned, I've written and had published 13 books. My father was a published author and a book reviewer. My son is a published author. And as it turns out, my 14-year-old grandson just contributed a chapter to a newly published book. So publishing is kind of a family business in the Kirsch family. And I'm always take a lot of pleasure in working as a lawyer, serving clients who are in the publishing business.
That's amazing. So then before you became the journalist, did you have any prior experience with publishing?
Oh, yes. Well, like many people who end up in either publishing or journalism, I was on the school paper, the school yearbook, in high school, also in college. And I was what was called a stringer, which is like a part-time reporter for the Time Life news service while I was in college. And I wrote for the local paper in my college town, Santa Cruz, California, the Santa Cruz Sentinel. So I had a substantial amount of journalism experience. I've been writing for publication for years and years before I got out of college and got my first post-college job at the LA Times.
So we're going to start diving into some legal questions that I think are important for any author or publisher to really understand. So let's just start first talking about copyright. Can you tell us what it is and what it means?
Yes. Copyright is an item of what lawyers call intellectual property. It doesn't refer to something you can hold in your hand. It's not physical property. It doesn't refer to something on the ground. It's not real property like a lot, but it is property that can be owned and exploited by its owner. And there are other kinds of intellectual property. Patents are intellectual property. Trademarks are intellectual property, trade secrets. But copyrights are specifically attached to works of authorship. And works of authorship could be a book, a poem, a photograph, a painting, a musical composition. It is the form of intellectual property that creative people create, own, and can exploit. Now, just one principle that we've got a lot, we could talk a lot about copyright, but one thing that you need to bear in mind is you don't have to do anything to own a copyright except create a work of authorship. If you sit down at the computer screen and you type a poem or a short story or a song, and when you press save, you have created a work of authorship. You have fixed it in a tangible medium of expression. That's the saving down to the hard drive. And that is when copyright springs into existence. You can use copyright notices and should. You can register your copyright in the US Copyright Office and should. But what makes you the owner of a copyright is creating a work of authorship.
And so when you register your copyright, what does that do for you?
The single most important thing about registering, as lawyers put it, is that it's the key to the courthouse door. You cannot sue anyone for copyright infringement unless you have a certificate of copyright registration. So, and there are advantages to these. We're getting into some technical areas, but there are some very specific advantages you get by registering promptly after publication, within 90 days after publication. That's the safe harbor period for registry. And you get the maximum legal protection to enforce your ownership of copyright.
So if it's after the 90 days and you haven't registered yet, is it still worthwhile doing?
Well, this is a very technical point, but let's dig into it. There are remedies you get in court that you only get if the copyright has been registered before the infringement. Now, most people, if they hear about an infringement and now they want to sue and they haven't registered, they rush out and register. But infringements have happened before that registration. So they're not entitled to those enhanced legal remedies and financial remedies. However, if you register within 90 days after publication, then it doesn't matter when the infringements began. It's retroactive. So just to give a clear example, suppose you're published on day 1. On day 2, somebody starts infringing, and on day 89, you register. You will have these enhanced remedies for copyright infringement for the previous 88 days of infringement, even though they took place prior to registration. If you waited until after the 90-day period, you would not get those remedies except for infringements that take place after the registration.
Okay, so it would still be worthwhile to do. It's just what protection you have from it is different.
That's correct. And
okay.
My advice is it's easy. Well, I don't know if it's easy to do, but most people do their own copyright registrations. It's done online. There are helpful tutorials at the Copyright Office. Only a very few clients ask me and pay me to do their copyright registrations. So it's pretty easy to do, and it's not expensive to do. And by doing it, you get a very important legal advantage. So my advice is register at the latest, not later than 90 days after first publication. And some people register their unpublished works. You can do that too.
And so let's talk a little bit about public domain. What does that refer to?
Well, public domain is a term that means not protected by copyright. Now, there are two ways that you can be in the public domain. One is that it's an unprotectable thing. It's not eligible for copyright protection. For example, an idea, facts, information are not eligible for copyright protection. They are in the public domain and will always remain in the public domain. So for example, if you wrote a book about the Civil War, the facts of the Civil War are in the public domain, and any number of authors have already written about those facts, and any number of authors can write about it in the future. The facts in your book about the history of the Civil War are in the public domain. The other kind of public domain is Even the things that are protected by copyright, which are the particular words and phrases and paragraphs that you created as the author to tell the story of the Civil War, your particular words, those will be protected by copyright under most circumstances for the rest of your life and for 70 years after you pass on. And then they go into the public domain.
So that kind of raises some interesting questions for like all of the Pride and Prejudice romance novels. You see, there's retakes on modern retellings of Pride and Prejudice and Jane Eyre and Emma and all these different books in the romance genre. So they're able to do that. Their work is copyrighted, but there are a lot of other people who are also writing that type of story.
It's a very important point you're raising. You know, every January 1st is known as Public Domain Day, because as the years go by, works that were under copyright fall out of copyright. We're up to the year 1926. Anything published in 1926 or earlier is in the public domain. Next year, it'll be 1927. Mm-hmm. And every year it gets kind of crawls forward. What that means is that if you go back to a 19th century book, anyone can print that book in its entirety as it was originally printed, or they can make what are called derivative works, which would be a retelling of the same story with the same characters. And the copyright will protect what is new and original that you added, but it will not protect what you found in the public domain book. Now, sometimes that's easy to tell. Sometimes it's a little hard to tell, but that's essentially what public domain means. It means it's available for use by anyone and everyone. And the only thing you can protect is what is new and original with you.
So a common question I hear from authors is about fair use. So let's talk a little bit about what that is and what it means to an author or a publisher.
Yeah. Fair use, I often describe it as the lubricant that keeps the gears moving in publishing, to be sure, but in all expressive arts, poetry and painting and choreography. Fair use is what lawyers call a defense, an affirmative defense to a claim of copyright infringement. It is applied when an author uses something that is under copyright, it's not in the public domain, but uses it in a manner and for a purpose that is defensible under the fair use doctrine. Publishers and authors rely on fair use every single day without anybody adjudicating whether a particular use of copyrighted material is or isn't fair use. All you can do is make a good guess, a well-informed guess. And then if you're sued for copyright infringement because someone doesn't agree that it's protected by fair use, then the court decides if it is fair use. And so that's an important principle. Now, I get paid by my clients to give fair use opinions all the time, every day, and I'm pretty good at it. But I have to tell them that not I and not any lawyer in the world can say this is fair use. All we can say is this is strongly defensible or weakly defensible or not defensible as fair use. And if you wish, we can talk about the fair use factors. There are 4 of them.
Sure.
But those are the factors we apply to determine if we have a good shot at fair use.
And what are they?
The first is the nature and purpose of the use. So for example, if you're using something for commentary, criticism, reporting, scholarship, that's a highly protected use. And the nature of the work that you're copying. If it's a work of fiction, it's less likely to be fair use. If it's a work of fact, it's more likely to be fair use. Another test is the amount and substantiality of the portion of the copyrighted work you're using. And if I could pause on that one, the most basic interpretation of the amount and substantiality test is less is more. The less you quote, the more likely it is to be fair use. However, if you're quoting something that by its own nature is short, and you're taking what the courts call the heart of the thing, the heart of the copyrighted work, even a short quote might be infringement rather than fair use. And if I can burden you with a war story, this is a really good war story. Some people listening to this conversation will remember when Ford pardoned Richard Nixon for the Watergate crimes. Ford later went on to write a 300,000 word memoir. The Nation magazine quoted the 300 words of that 300,000 word book that described the pardoning of Richard Nixon. And that was held not to be fair use, because even though it was a teeny tiny fraction of the book, the court essentially said, that's all anybody was really interested in the life of Gerald Ford. So you took the heart of the book. And that was a useful lesson, that sometimes, even if the work is long, a small quote might be infringing rather than fair use. And of course, if you're quoting something like a poem or a song, which by nature are short, unless it's a Bob Dylan song, the risk of infringement is heightened, because even a relatively small number of words might be a big percentage of the poem or song.
Yeah, we had a manuscript come in once that had a Khalil Gibran poem in it, but it was the entire 3-stanza poem. And I said, you can't do that because it's too much. It's, the entire poem is not going to hold up to
Well, I
fair
have
use.
a question in my mind whether Khalil Gibran is in public domain due to the age of the work, but that's a question that can be answered. That's the first question. Is the work protected by copyright? Then, if so, is there a fair use argument that can be made? By the way, the other test is the effect of your use of the quotation from a copyrighted work on the market for the work itself. So if you take so much of a copyrighted work and use it in your book such that people don't really have to go buy the copyrighted work, they can just buy your work, that is a factor that disfavors fair use. The final thing I'd like to say on this subject is there are all kinds of myths and legends about what is fair use. You'll hear the 3-bar rule or the 300-word rule, the 20% rule. There are no such rules. There are absolutely no such rules. It's true that publishers used to say on their copyright notice pages, quotations of up to 300 words are permitted for use in a published book review. That's where the 300-word rule came from. Has nothing to do with fair use. That was a publisher announcing that we won't regard it as infringing, or essentially giving permission for use of 300 words in a review. As I've just mentioned, 300 words was too much for Gerald Ford's biography, and so no such measure exists.
And so one of the things I'm curious about then is when it comes to like the chapter quotes, where somebody will put something inspiring after each chapter title. It's not really something that the book is building on, critiquing, commenting on. It's just kind of setting the tone for that chapter.
You have raised one of my favorite subjects, absolutely favorite subjects. Those are called epigraphs. They're little quotes. They hang under the chapter title, and they're meant to set the tone or to inspire or to point the reader in the direction and get the reader thinking about something. I love using quotations in that manner, including quotations from songs, which are often very inspirational and call up memories that are appropriate for the book. I had one publisher, it was actually Random House. I had a book where I used a Paul Simon song, and the lyrics that I hung up there were, angels in the architecture spinning in infinity.
Mhm.
And my editor at Random House says, cannot do, get permission. You can't, we're not gonna let you do that unless you get permission. I didn't want to go get permission because it's complicated, it's expensive. Sometimes they say no. So I bargained with my editor and I said, how about if we cut it down from angels in the architecture spinning in infinity to just angels in the architecture. So it's open quote, ... angels in the architecture, ... close quote, Paul Simon. And they accepted that. They accepted that fair use position. And luckily, nobody was sued. But that's an example of how picky and defensive publishers can be and often are. And that's the advice I give when I'm counseling a publisher. That's a risk.
Mm-hmm.
Then I had a book published by a different publisher who said, no quotations in epigraphs, period, unless you clear them, unless you get permission. Moving the quotation from the epigraph into the body of the book, that's okay, because that's for purposes of commentary, criticism, analysis, reporting, scholarship. That's defensible because there's a reason why you're using the quote. Just hanging it up there like for ornamental purposes doesn't fall into a fair use category, and we're not going to let you do it, period. So that, I'm not going to mention that publisher's name because I don't want to get them in trouble if they've changed their policy since I did this. But those are examples of how sensitive publishers are to the use of chapter quotations, which are absolutely ubiquitous. They're everywhere.
And so because they're ubiquitous, does that mean that it's okay to do it? Or
No. It means that it represents a risk. And I've given you two publishers, both major New York publishers, who are sensitive to it. One who would take a shortened quote in reliance on fair use, and one that absolutely take no quoting without permission. So it's a risk. No, the fact that it's done so commonly doesn't mean anything legally, although it may help you assess the likelihood you're going to get sued. People are not sued commonly for that. But what I tell my clients is, at a minimum, when you hang that quote up, give the author who wrote that quote the title of the book in which it appeared. Because one of the principles of fair use is that attributing the quoted material is evidence of good faith, and it raises the defensibility of the use of that quote. So I always encourage the author or publisher to attribute the quote to its actual source, on the theory that if anybody wants to go and read that book, they'll know where to find it.
That's often something that we have to discuss with our authors too, because a lot of people will find a quote that they like on Brainy Quote and think that that's fine to use. And it's like, no, most of the stuff that's on Brainy Quote isn't even accurately.
Well, that's another issue. Yeah. I mean, the internet is a great tool, but it's not a reliable source of information, and quotes can be misattributed. One thing that's very common to see is someone announcing on the internet that something is in the public domain when it isn't. I mean, that's not a way to find out if something's in the public domain because someone on the internet says it was.
I know there's a website, a government website, I believe, that you can go to be able to look up what's in the public domain, right?
Well, there is a database at the Copyright Office website, and you can look up works that are under copyright, and you may find the information you need to determine if it's still under copyright. It's not 100% reliable for that. If the book was published after 1978, you'll know that in the United States, it's probably still under copyright. If it was published before 1978, it might be and it might not be, depending on whether the copyright was renewed and when it was renewed and when the author died. I mean, there's all kinds of information that goes into determining copyright status that's not readily available. It takes a little work.
We have a lot of people submit manuscripts that are memoirs to us. And so that's kind of one of the questions I want to touch on next is if you write a memoir, but change the names and locations of people involved or those individuals are already deceased, is that sufficient protection or is something more needed to be able to produce that memoir?
Well, that's a good question. One of the services that I offer is what we call vetting, vetting. Vetting means reviewing the manuscript of a book to identify legal risks and then to address those risks. I would say that probably half of all the manuscripts that I vet are memoirs. The answer to your question is that changing names is a good measure, but it's not bulletproof. And there are reasons why. First of all, even if you change the name, if you leave in other identifying details, it's just as if you use the name. If the person reading the book can figure out who that fictionally named person actually is, it's as if you use their real name. Another issue is, it comes up all the time in memoirs, is that if you're writing a memoir and you're writing about your own parents or your own siblings or your own ex-spouse, the cat's out of the bag. The fact you give them a fictional name is meaningless because anyone who knew you would know who those people were. So those are not bulletproof strategies, but they are often used. What I always say to the client is, you need to be thorough about it. Don't be cute about it and use a name that's a clue to the real name. I've seen that happen a lot. Don't change just the name, change the other identifying characteristics. And I always say, use an author's note at the beginning of the book to tell the reader what you're doing. Because if some of the names are fictionalized and some are not, the reader has no way of knowing which one is fictional and which one isn't. So I always encourage the author to put an author's note that says, here are the fictional names, and list them. All names are fictional. Whatever the method the author has used in terms of fictionalization should be announced to the reader. And the bottom line is that it's, as I say, you could still get in trouble. I was once asked to be an expert witness in a libel case against the author, interestingly, of a novel, not of a memoir at all. The author of the novel, and the book was labeled as a novel, and there was a little disclaimer saying this is a fiction, this is a work of fiction, and any resemblance to real people, living or dead, is strictly coincidental.
Mm-hmm.
Just wishing doesn't make it so, because in fact, she talked about a person. I'm going to be kind of discreet about this. She talked about a particular person in a particular community who had certain features, the work she did, incidents in her marriage, things that were unmistakably unique to this person. And then she had this person behave in outrageously negative ways. This person was drunken and she was promiscuous. She did all kinds of things that a person would be embarrassed if the world thought that's how you really acted. So the author, on one hand, gave clues to the identity of the character by using real identifying details, not the name, and yet attributed unflattering behavior to this character. And there's no way for the reader to decide, well, I recognize that person. I didn't know that person was such an outrageous person. Mm-hmm. That went to a jury trial, and the plaintiff in the case won. The author lost because they had not taken care to hide the identity of that person.
Now, if the identity was still there, but the actions were positive, would that have made a difference?
No, because bear in mind, defamation is based on saying something, we're actually writing something false, and derogatory, false and damaging. If it's false but not damaging, it's not libel or defamation.
Okay.
There's also something called invasion of privacy, which is true but nobody's business and damaging. So, for example, if you talk about the words that the lawyers use is, if you write about something that is absolutely true, but falls within what the lawyers call the reasonable expectation of privacy, and it's embarrassing to the person, that's a separate lawsuit. That's not defamation. Truth is an absolute defense in defamation. It has to be false to be defamation. If it's true, it could still be invasion of privacy.
And does it make a difference one way or another if the individual being written about is alive or dead?
Oh, very good, excellent question. In the United States, only the living can file defamation or invasion of privacy lawsuits. There are countries in the world where a lawsuit can be filed by a relative on behalf of a dead person. In the United States, you have to be alive and kicking in order to file a defamation claim or an invasion of privacy claim. You don't have to be alive to file a copyright claim, because copyright as intellectual property passes to your heirs, and your heirs can file the lawsuit.
Okay. So let's move on to endorsements. When someone provides an endorsement for a book, can it be used for marketing materials as well as in or on the book, or do you have to specify up front how it's going to be used?
Another excellent question. And this is another item of intellectual property, which I didn't put on my list at the beginning of our conversation, but it belongs on that list. This is what is called the right of publicity. And the right of publicity is the right to use the name or likeness of an individual, living or dead, for advertising, merchandising, or endorsement. And permission is needed to do that. As a general rule. Now, in different states of the union, the law is different from state to state. But as a general principle, if a blurb on a book is a right of publicity issue, permission is needed to use someone's name in a blurb.
And so if they've emailed you that endorsement, is that considered permission, or do you need a signed form?
Very, very good question. As lawyers see the world, we would rather you use a signed form. And a signed form would be a better way to address the question you actually asked, is what is the scope? What is the range of uses that you're permitted to make of the person's name and their blurb, their words? If you have a drafted permission agreement and the person has signed it, then there's no argument about it. It's in the contract. So lawyers prefer contracts. However, if I write you a letter, an email, and say, will you send me a few words that I can use as a blurb on my next book? And you press reply. And in your reply are a few words of endorsement about my book. That is probably an enforceable contract. In most states, that would be an enforceable contract. It would mean I asked, you responded in a way that indicated your consent, and you provided me with the words to use. Now, the difference between the two approaches is it's less reliable if it's by email, exchanges of email. For example, could that person withdraw their permission? Could they write you a letter and say, I've changed my mind and I don't want you to use my blurb anymore, or you did something that offended them, or they don't want to be associated with you? If it's just an exchange of emails like that, I think it's pretty clear that the blurber, the endorser, can withdraw the permission that was impliedly given in the email. Now, under principles of law, that person probably can't make you pulp the books that are already in print, but they probably able to say to you, don't put that blurb out after today. Anything that you create after today shouldn't have that blurb. If you have a formally drafted permission agreement, it would bind the person signing it to the stated terms, and the stated terms could say for as long as the book is being published. And to address your specific point, whether it was in the email or whether it was in the formal permission agreement, you would want to say, I want a blurb that you authorize me to use on my book and in the related advertising, publicity, and promotional materials for as long as the book is being published. If you put that in the permission agreement or you put it in the email and it came back, I think you'd have a defensible position just on the basis of the email, although it would be better to have the signed agreement.
I've found many times when they do send back the endorsement for the blurb, they're starting a new email. So they're not replying to the original request. So that would create a disconnect that doesn't really say this
exactly. If that, now I have to tell you, Tara, I have the opposite, which is I get all emails seem to be cumulative back to the beginning of time, so that I no longer print them out because they just choke my files. Everybody seems to just use one email chain. But if it were to happen that you sent a clean email with the request and they send a clean email with the blurb, I would write back and attach the blurb and say, thank you for giving me permission to use the blurb pasted below in my book, on my book, and in the advertising, publicity, and promotional materials for my book as long as it is being published. And then that email chain would have legal weight. If the other two, two disconnected emails is going to have a harder time.
Yeah. Okay, so let's talk about permissions for quoting a work. When you do seek out those permissions, how do you identify the current copyright holder? Because sometimes that can be really challenging.
It's very challenging. It can be very challenging. It can be challenging for a number of reasons. One is that the current copyright holder may not be the author. That author may be dead, and or the author may have given the copyright to somebody else. As a general rule,
we've also found publishers have been acquired, and so the publisher was a copyright holder, and the publisher we reached out to didn't exist anymore.
Yeah, that happens too. And there are things. Let's pause on that notion. Copyright law not law, but copyright lawyers refer to something called orphaned works. Orphaned works are works of authorship that are still protected by copyright, but you can't find the owner. You don't know who the owner is, or you know who the owner is, but you can't find them. There were a lot of people at a certain period, I noticed, that would put into their book, every effort has been made to identify and seek permission of copyright holders. In some cases, we weren't able to find the copyright holders, and we invite them to contact us. This is like a sign saying, we are infringing your copyright. Because just because you can't find the copyright owner doesn't mean it's now okay to infringe the copyright. That notice is calling attention to the fact that you don't have permission. You always would start with the latest publisher you can find and address their rights and permissions department and say, we have a quote, it's in a book you publish, we'd like to get permission. If they have gone out of business, you could do a Google search to see if they were acquired. Nowadays, publishers are vacuumed up all the time. It may end up at one of the big 5 or the big 4. You may be able to find someone who does have the copyright. If the copyright is owned by a dead author, there are records you can search to see who their heirs were, find out if there was a probate. But sometimes you'll go to all that trouble and come up empty. And at that point, you just have to make a decision. Am I going to use this material without permission, take the risk that somebody's going to come out of the woodwork and sue me, and I won't have a defense? Or will I not use it and avoid the legal problem? And that's not an easy problem to solve, but those are the rules of the game.
And usually if they do sue you, it has to do with how many copies were sold to figure out the damages. Is that correct?
The measure of damages in copyright infringement is measured by the losses of the copyright owner, what the copyright owner could have made if they had sold the copies, and the profits of the infringer. Those are the basic measure of damages for copyright infringement. Now, earlier in our conversation, I talked about the enhanced damages that are available when the work has been registered. And one of those is statutory damages. Now, statutory damages are fixed dollar amounts that the court can award without proof. You don't have to prove what your losses were. You don't have to prove what the profits of the infringer were. You just ask the court to decide. Now, the problem is the range doesn't go very high. I think it's $150,000 now. That I've had clients say that's not worth hiring a lawyer and going to court. It's just not a big enough prize to justify the cost and risk. You might not win at all. And if you do win, it might be what you paid your lawyer. The other problem with statutory damages is they start very low, $200 per act of infringement. And that's not per copy. If you've infringed a book, it doesn't matter how many copies you've printed. And at $200 is for what's called innocent infringement, that the infringer thought it in good faith, thought that it was not an infringement. And then it steps up to the high end according to the discretion of the court. So in some cases, that's an advantageous situation because you don't have to conduct discovery and prove loss. On the other hand, you do have to convince the court to go high on the scale. And as high as you go, it's not going to be a huge amount of money.
Okay. So let's talk about reviews that are left on public websites like Amazon and Barnes & Noble and things like that. Can you use those reviews in your marketing material or on your website?
The basic rule is it is fair use to quote from a published review. People do this all the time and they don't ask for permission. So if the New York Times reviews a book and you quote selectively from the New York Times review, nobody is asking the New York Times for permission and the New York Times is not going to sue you for doing it. You can't reproduce the entire review without permission. And from time to time, I've seen in my, excuse me, I'm sorry, I'm going to take this. From time to time, I have seen, especially in the motion picture business, producers who get a great review and they publish the review in its entirety in an ad. That has to be pursuant to permission and paid for. But selectively quoting from a published review is considered to be fair use. I would argue that posting to Amazon is comparable to writing a review as a freelance writer for the New York Times. It is a published review in the sense that anybody can go online and see it. So I think quoting from that review would be defensible as fair use. Now we get to the technicality. As lawyers, we're always worried about technicalities. Suppose someone put a 3-line review on Amazon and you use the 3-line review. That's 100% of the review. We've already discussed that amount and substantiality is an issue. That's a potential legal risk. You might want to at least try to find your way to that poster, the person who posted the review, and ask for permission.
Okay. Good information. So what's the difference between I'm gonna ask one more question related to it, because on Amazon, each review has its own permalink. So you can link to a URL that takes people specifically to that review. If you were to use that, say, in social media and link to the whole review, is that because you're pointing people to the original source? Is that okay too?
As a general rule, a link out from your website to someone else's website is not infringing. Framing it inside your website could be infringing.
Okay.
So if you had a link at your website that says, read what they're saying about this book on Amazon, click here.
Mhm.
And that click exited your site and delivered the user to the Amazon site, that's a defensible thing to do.
But if you created an image of the quote that then is a clickable image that takes them to the quote on Amazon as well, is
Well,
that
what I've seen done and what I think is appropriate to do is to quote 2 or 3 or 4 words of praise, great book, exclamation
Mhm.
mark, and then hyperlink from that. But it's always a good practice to alert the reader that this is something that appeared on another website.
Yep.
And this is a link. I mean, all you have to say is, see what they're saying about us, this book on Amazon. Then you quote 3 or 4 words, and those words are hyperlinked. So they click on it. I think that's a defensible, fair use. And it follows the rules of letting the reader know they're going away from your site, they're going to another site, and where they actually read the review in full is the other site.
So going back to quoting other people's material inside your book, I've seen times where people will quote somebody, and in the context of the quote, they'll say, you know, author so-and-so in such and such had this to say, and they quote it. I've seen others where they have the quote and a footnote that references the book and where it came from. Or I've seen times where nothing is said in the text, but that book is included in the bibliography. What's the proper way of kind of handling those quote references?
Well, I am a big fan of endnotes, and in all the books that I have written, I've written a couple of novels, but all of my nonfiction has endnotes. So there's a number and a set of endnotes, and the citation for the quotation is available to the reader. And I think that's a best practice. There's another way of using footnoting nowadays, which is not to use numbers in the text, but to repeat a portion of the quoted phrase in the endnotes, so that the person can go to the endnotes and find the phrase that they saw in the main text, and then they get the site. Of course, there's conventional footnotes on the page, which in my experience, publishers disfavor because they think it clutters up the page. But those are the conventional ways of identifying the sources. Now, several of the books that I've written have been about biblical texts. And in those books, I always used a initial for the version, RSV, Revised Standard Version, or KJV, King James Version. And I explained that in a note to the reader at the beginning of the book.
Mm-hmm.
And so there are no footnotes or endnotes. It's just that the letter code for the source of that quotation appears in the text. All of these things are appropriate to do when you're relying on fair use, because sourcing and crediting the source is a very important principle of fair use. I also think it's good for the reader. The reader is entitled to know, and in many cases wants to know where the quote came from. But you could also, I mean, you could in fact insert the name of the author, the title of the book, even the page number in parentheses wherever the quote appears in the main text. And that's often done in scholarly books. But I think most publishers would not be comfortable in doing it because it really clutters up the page. It really slows down the reader.
Okay.
That's not a legal issue, but
Yeah, I think it depends sometimes on the design of the page. And the thing is you can't switch back and forth between, this chapter is going to be footnotes and the next one's
yeah,
endnotes.
no,
So you have to look at the overall layout of the book. So if you've paid someone to produce something used in the book, for example, an illustration, a photograph, an index, is the invoice sufficient protection or is something more needed?
The invoice alone establishes that it's not an infringement, I guess. If it depends on what's written on the invoice. If the invoice is sufficiently detailed to identify what it is that you're paying for, what quantum of work, if it just says illustration or black and white illustration with a date and a charge, there's no way to connect the invoice to any particular illustration. But even if the illustration or the index or whatever contribution the person has made, even if it is identifiable, the invoice doesn't say anything about the permitted scope of use. By the way, photographers and artists will tend to say one-time use only or one printing only. I once represented a publisher who was sued for copyright infringement because they had taken a photograph, paid a license for it, and used it in 7 different editions of the same book and multiple printings of each edition. And I said, well, where's your permission? And he said, I've got a permission. He handed me an invoice. That was the permission. And it said one printing only on the invoice. So I said, well, you've self-evidently exceeded the scope of permission. Mm-hmm. So the answer to your question is an invoice could be enough if it says the right things. It's better, lawyer speaking, it's better to have a permission agreement that says what it is, what right are you acquiring, what are you able to do with it, and for how long can you do it, and what kind of credit do you have to give for it, so you know the rules of the game. That's the best practice.
Okay, so let's kind of flip things around a little bit. We've talked about permissions and using other people's content. Let's talk about what exactly is plagiarism.
Well, plagiarism is an antique word that means putting your name on the work of other people. Plagiarism is not an active legal doctrine in our place and time. You don't really sue for plagiarism. You would sue for either or both of copyright infringement. If you took somebody's work, wasn't your work, it's protected by copyright, and you publish it without permission, regardless of whose name is on it, that's copyright infringement, and you'd sue for copyright infringement. Mm-hmm. There's also this right of publicity concept, or it might fall under the label of unfair competition, where the author would say, in addition to the real author of the work you've claimed as your own work, might sue you for unfair competition or misappropriation of the right of publicity by saying, you're taking credit for my work. People think you wrote it, but I wrote it. I've been damaged in that way too. I'm not being credited with the authorship of my own work. That's a separate issue. That's not a copyright claim. You could get sued for both of those theories. But we no longer use the word plagiarism except informally. Plagiarism is technically means putting your name on the work of someone else.
Interesting. I've also been reading recently about self-plagiarism. Can you talk a bit about what that is?
Well, I'm not sure how that term is being used, but one way I could, if you repeat something you have written and credit it to yourself, that's not a wrongful act per se, because you are the author. You're just quoting yourself, or you're reusing or recycling something you wrote. Now, what could happen, and I've run into this too, is that you write something, you sign a publishing agreement with a publisher, the publisher publishes it, and now you recycle what's in that book in another book by another publisher. That's copyright infringement if you are using rights in that work that you have given to someone else. And the person who sues for copyright infringement is not the author, it's the publisher, the first publisher.
Okay.
That has happened. That has happened.
Well, that leads me to another interesting question, because our authors will often ask us after we've published their work, how much of their work can they use, say, as a LinkedIn article or something else in order to promote the book? And that's always a little bit of an awkward question to answer. Do you have a response we should be giving to that?
Well, I have two responses. The fundamental response is it depends on what the publishing agreement says. I have drafted, at the request of my various clients, publishing agreements that say the author is giving all rights to the publisher, and the publisher is granting permission to the author for the following uses. They could teach a class, they can use a handout in a class that they personally teach, things like that. So that the publisher can define in the contract what downstream uses, follow-on uses are permitted. Another way to approach that is that the publishing agreement might grant the publisher restricted and defined rights. And that would mean anything that isn't in the contract. That's not an all rights contract. That's a some rights contract. If the contract says, here is a list of the rights that the publisher owns and everything else remains with the author, then the author can do anything that the author hasn't already granted the rights to the publisher to do. My recommendation is, since you've invited me to give it, is I would start by reading the contract, and this would be advice to both the author and the publisher. Read the contract, see what it says. Does it answer the question of whether the author can do what the author wants? And if the publisher controls the rights that the author wants to use, it's within the publisher's legal rights to say yes or no, or to condition it. So if the publisher owns and controls the rights under contract, you could say to the author, for example, you can use up to 1,000 words or 500 words or 750 words.
And is
you
that
can
per
use them,
use or in all?
well, if the publisher owns and controls the rights, then the publisher calls the tune, so to speak. You tell the author what you're comfortable with.
Okay.
Now, there are other issues at work here. If you want to have good relations with the author, if you want to do another book with the author, you may be more accommodating as a publisher and take a more lenient view on permissions. But you also have the right, if the contract says so. Everything depends on what the contract says. If a contract says, for example, all rights, this is an all rights contract. Author has granted all rights to the publisher. And it doesn't have anything in it by which the author is assured the right to do any particular thing. Then you just say, this is what we're comfortable with. And you may have an unhappy author, but if your contract justifies it, you're relying on your rights.
Mm-hmm. Okay. So I know we've covered a lot of territory, and any one of these topics we could have spent the full hour on. Is there anything else that you think we've missed that you think we should touch on that's important for authors and publishers to know?
Well, I want to say, I think you've done a great job of covering the waterfront, and we've touched on a lot of the issues that I'm asked to address from day to day in the work I do as a publishing lawyer. So
thank you.
There are no glaring omissions.
I'm glad to hear that. It means we must be learning something.
Yeah.
So thanks so much for that. I understand that you've contributed to the prize for our conference giveaway, and that you're offering a 1-hour complimentary consultation for 2 different people. So I really appreciate that. Anyone who's interested, just make sure that you're attending the sessions, and you will be added into the drawing, and we will let people know who the winners are at the end. And Jonathan, what's the best way for people to connect with you after the summit if they want to talk to you further about any
I
of these?
always say I'm the most accessible lawyer in America. I mean, I'm easy to find. First of all, my website for client referrals is jonathan-kirsch.com, www.jonathan-kirsch.com. That'll get you to a referral website. It'll give you information about me, and you'll be able to leave a message for me, forward a message to me. You can reach me directly by email at jk@jonathankirsch.com, no hyphen. The email address does not have a hyphen. jk@jonathankirsch.com.
All right. Well, thank you again, Jonathan, for being here. I really appreciate you letting me throw all these questions at you. And I know they're ones that as we have come through the industry, we've had to wrestle with trying to find the answers to ourselves. So I think this is going to be really beneficial to our listeners. For our attendees, I hope you found this valuable, and I look forward to seeing you in the next session. Bye.
Thanks, everyone.